So we have a few participants who have joined in, and I'm sure we will have some more to come in because it's a Sunday morning and probably they're taking a little bit of a time. However, let's get started, Meenakshi.
Good morning, ma'am.
Good morning, Nagaraju and Priya. Welcome on a Sunday morning. Good morning, Priya. And I'm sure today is going to be a very, very useful day, a very informative and learning, day that we would have all through. In yesterday's session, we discussed quite a bit. We had quite a few sessions which dealt with commercializing intellectual property, wherein we learned very many aspects of licensing, assignment, technology transfer agreements, etc. And today's sessions are dedicated specifically to intellectual property management, how firms and large organizations actually manage their large IP portfolios is something that we're going to learn through today's sessions. And we have a stellar of excellent instructors who are here with us today. And the present session is going to be on IP docketing, the docketing aspects of it. And we have Miss Meenakshi, who is here with us. Before we begin with the session, I'm happy to introduce the instructor for the session. Meenakshi is a managing associate at LexOrbis. She is a registered Indian patent agent and the Karnataka Bar Council member. She holds a master's in biochemistry and a bachelor's in biotechnology and law. Excellent combination, I would say. She has over 11 years of rich experience in strategic business counseling on intellectual property matters, and she partners with commercial and scientific teams to develop comprehensive and cost-effective global IP portfolio. She has represented multinational and domestic clients in India, PCT, and global patent drafting and prosecution. She also represents clients in prosecution and opposition hearings at the Indian Patent Office and also matters with the National Biodiversity Authority of India. Meenakshi has expertise in conducting due diligence, handling oppositions and third-party observations. She has expertise in conducting various search and providing opinions on matters that relate to patentability search, freedom to operate search, invalidation search, equivalent search, etc. She represents a wide range of clients across life science sectors, which includes biotechnology, chemistry, biochemistry, medical diagnostics, to name a few. And she delivers seminars on various platforms on Indian patent law and patenting strategies. Welcome, Meenakshi, and thank you for being with us through the session today. Over to you. And just a very brief introduction about our participants. So Nagaraju and Priya are law students. And Tejal is a professional. She's a lawyer and she's on the corporate side. We also have Hasnain joining in. And yeah, so this is a mix of, professionals and law students. So just wanted to give you a heads up. Thank you.
Thank you. Thank you so much for having me, Dr. Pratima. I'm really excited for this topic in particular because often what happens is when you're talking about IP law, we go into the actual nitty-gritties of the law so much that we overlook one of the key aspects which actually keeps law firms and companies running in terms of IP. So I'm very glad to be here for this session. And thank you everyone for joining us on a Sunday morning. Really appreciate you joining the session.
Sorry to interrupt, just one moment. I would also request the participants to keep their videos on so that it may be a little more interactive and the interaction may be more impactful, which is why I would request, I would leave it to the participants again.
Thank you.
Yes. Please.
So once again, thank you everyone for joining us for today's session on intellectual property docketing. So at any given point of time, law firms and large companies will have over thousands of patents in their portfolio, which they need to look after. So if there is no systematic plan in place to track and maintain your matters, it's very easy to lose track of this, which is why IP docketing comes into picture. to keep this process smooth and make sure that you do not lose out on very valuable intellectual property assets. So if you look at the definition of IP docketing, it is simply a systematic process of managing and tracking important deadlines, tasks, and documents related to intellectual property assets, such as patents, trademarks, designs, and copyrights. Now, the whole purpose of getting, making sure that you have a IP docketing system in place is to ensure timely legal compliance and protection of your intellectual property right, minimize the risk of missing critical deadlines, which could actually have severe consequences on the business of the applicant, and facilitate an efficient organization, management, and strategic planning of IP portfolios. We are going to look into all of these aspects in a little more detail in here on. So I think I had not planned for the toolbar to, okay, so I think I've overloaded this. Oh, great. Okay, so coming back to importance of IP docketing. So now, while I speak about IP docketing, I will largely be speaking from an IP law firm perspective, but everything I say here will also stand good for in-house organizations and companies who are maintaining their IP in-house as well. And this is largely important for big filers such as, like, for example, Samsung, who has filed roughly about 5,000 cases, patent cases in US alone. So this is going to basically stand good for both sides. So first and foremost, it is important to keep track of your inventions and safeguard your invention brands and creative works. So it will help you comply, take care of legal compliance and avoid penalties. So basically, you can keep track of all your statutory deadlines and regulations and make sure that they are getting timely filed and taken care of so that you don't have to pay any penalty fee associated with a late filing. It helps you in efficient portfolio management. It will streamline workflows and optimize resource allocation. So basically, when you have like so much of the matters associated, all firms and organizations would work with having designated people doing specific roles, and this platform will allow you to make sure that different the work can be allotted to different teams, different individuals, and it can still be streamlined in an efficient manner. It helps make informed decisions on comprehensive view of IP assets, which is very critical for making strategic decision making. So, for example, let's say you have a company who has filed several patents all over the world, and they have now decided that for one particular technology they do not want to commercialize their IP anymore in Japan. So now it is easy if all the information is located in one place, it will be easy for them to basically pull out that information and see, hey, these are the patents which I have in Japan, and these are something which I can let go of, so I don't need to maintain them or pay the annuity fees. So it helps them make a very strategic business decision in a comprehensive manner. It helps integrate with legal workflows. Like I said, law firms and organizations will have different teams working in different aspects of the same case as well. So it helps in efficient collaboration as well among the legal teams. It streamlines the workflow and helps manage the workload effectively by prioritizing tasks based on urgency and importance. So what is linked to the importance is also the benefits of IP docketing. So the following are the benefits of what really happens when you are able to do and have an efficient system in place for docketing your IP. It helps you timely comply with all the legal deadlines, ensure that you adhere to the filing, prosecution, and maintenance of your matters. It increases the efficiency in tracking deadlines. Automation is really a time saver, and it helps you to effectively take care of such cases. It helps in mitigating risk, which is associated with missing on a important deadline and losing the having a risk of losing the rights to your IP. It enhances your portfolio visibility. It's basically a centralized view of all your IP matters in one place. So you can basically pull out reports to see what really you need to see at any given point of time. It again helps in strategic planning. It minimizes manual intervention, and reduces reliance on traditional paper-based records. So honestly, when I started my career, like in 2011, while we did have IP docketing systems in place, law firms were actually relying on physical files a lot. So I remember that when I was working, every single email communication or attachment that was sent from my end, I would have to take a printout. Sometimes the specifications would run in like over 100 pages. So we had to, the IP file would be it had to be absolutely comprehensive, and every single communication by any team member on that particular matter had to be filled in the file. But over time, like law firms have moved away from physical paper-based records, and they've realized how cumbersome it can be to actually get information out when you need it. So most of them have actually now moved on automating it, having everything centralized in shared cloud platforms in a safe manner. So it is actually enhances the accessibility to all the information, even when you're working remotely, which became very important post COVID. So to do basically all the IP docketing for IP docketing, the most original, like the oldest form you could think about is, of course, earlier on it used to be physically taken care of in calendars, planners, and diaries. You would have secretaries who would physically docket important matters, what needs to be taken care of, and remind the person in charge in a timely manner. But of course, with increased volumes, this is very difficult to actually sustain for a long run, and automation of IP docketing was absolutely inevitable. Uh, Excel sheets is also something which is used even till date to actually keep track of all the information that you need to take care of. However, that also lacks certain automations and specific features, which is why these IP docketing softwares have come into place to automate and streamline the management of IP related tasks, the deadlines, and documentation. So, this basically will enhance accuracy, efficiency, and collaboration in IP docketing processes. So, what are the key elements and features which are important or part of your IP docketing software? Now, the first and foremost, which is like really a big time saver and increases your accuracy significantly, is a rule-based calendaring feature. So now this is going to automatically, like IP docketing softwares will have, inherent uh, uh, formulas, you may add these formulas at your end as well. So they are going to automatically calculate deadlines based on relevant IP rules and other regulations, which reduces the risk of errors and missed deadlines. Now, so for example, I understand that you have already had a session on patents and what the overview of patent filing and what are the timelines associated with it. So I'll be going through that a little bit as an example so that I can give you specific examples for each of these features. Now, for example, you are aware that if a request for examination has to be filed 48 months for an Indian patent application, it has to be filed within 48 months of filing of the earliest priority date of your application. So once you enter in your docketing system what your priority date is of your patent application, the docketing software will automatically calculate the request for examination date as 48 months since your earliest priority. And based on that, it will automatically generate specific reminders. I don't just need to see if there's a chat. Okay, Tejal, I'll just get back to your question after this session, after this key elements and feature. So hold your question till we're done with this part, and I'm hoping it is addressed in the next few points we discuss. Okay, so yeah, so like I was saying, request for examination, like once you enter the priority date on which your patent application is filed, the docketing feature will be able to calendar the request for examination date automatically, and then it will be programmed to set reminders in a timely manner, saying you may also take care of that at your end on if you want to vary the frequency, but it is something which you can also pre-decide. There will be automatically a task updated saying, hey, a reminder needs to be sent out to client for filing request for examination. And this reminder will remain open till you actually enter the date on which you have actually filed your request for examination. So once you file the request for examination, the entire reminder system which is going to be in place for reminding you to take care of this deadline will remain open. Next is task tracking. So IP docketing systems are lifesaver when it comes to monitor the progress of various tasks related to IP matters. It also helps in assigning, tracking, and managing tasks through the software, because at any given day, law firms and companies are going to have several due dates that are falling on that day itself. And also, you need to pre-plan. Some of these matters have to be taken care of 1 week in advance, 1 month in advance. All of that is going to be there. So once you are able to, based upon your requirement, you can pull out from your IP docketing system that what are the matters and tasks which we need to take in care, say, for example, in February or in this week. And on a daily basis, there will be somebody assigned in a law firm who's going to make sure that there is no task which has not been taken care of the end of the day. So they're going to even take out, like today is, let's say if you want to know if all the deadlines have been met for Monday, and you put the date for Monday, pull out these are the pending deadlines left, you send them to the concerned person or the concerned team. And at the end of the day, there will be someone who is monitoring that they have been taken care of. So it helps in monitoring and tracking your matters. Plus, also when supervisors are assigning cases to the colleagues, it really helps and pays off to know how much workload they already have on their table, so that you don't overburden one person or delay. A person is not going to be able to pick up an urgent matter if there's already another urgent matter on their plate. So it really helps in deciding who in the team is best placed to pick up this matter and take care of it. Third is deadline management. The system helps in alerting and generating reminders for critical filing and response and maintenance deadlines. The alerts are customizable, provides for reminders and deadline tracking. So this deadline system is going to be in place right from the beginning. It will give you sufficient time to actually finish the matter, send it out to the client. You may have to send reminders to the client also for them to get back to you. So all of this will have a specific reminder, and it's going to be easily monitored if you have an IP docketing system in place, which sends you these reminders to take care of it. Another feature is document management. Now, this could be part of your same IP docketing software, or your firm may be using a different docketing software for doing this. But this is one of the key features which helps you actually, take away the manual process completely and not have to use a file to keep track of things. So every single email communication, every single document, every single version of a draft sent from your end, once you release it, it can be documented in the central cloud storage space, which is usually called a document management system. And it will be identified by a unique ID, which is going to be specific for that case. So let's call this as a docket ID. It's usually alphanumerical value, which is going to identify the case, a specific case in hand. So all you need to do is take this docket value, docket number, and add it in the docket management system. And you will get all the communications pertaining to this particular case, which have gone to the client. So it helps you keep track of things in future in case somebody who's working on a matter is not present, or you are not copied in any email and you want to check what happened on this communication so that you can take that matter forward. It is possible for you to basically look at this without even needing a physical file or checking with someone else. Another key element of IP docketing is communication tools. Now, these tools basically facilitate collaboration and communication among team members. Some of these tools can provide in-app messaging, comment features, and collaborative document editing. So what really happens is, like, even though you try really hard to keep all the deadlines and everything in track on record, but what happens is there are some unforeseeable events, or there may be some events which occur where there is no clear way of you docketing that in the IP docketing software itself. So in this case, it really helps. All these docketing tools will have a feature where you can describe what has happened, so that somebody else looking at the file will know what's happened and why is there a stall and why the deadline has not been met. Like I can give you a very, very simple example for this. Now, let's say we have a hearing issued by the Indian Patent Office on Monday. So it is on Monday, but the client has instructed that they need more time to prepare for it and they would like to seek an adjournment. So 3 days before the hearing, an adjournment was filed with the Patent Office, but we have still not received a fresh hearing notice. So the due date of Monday is actually not going to be met because we don't have instructions to attend and we have to seek and we are waiting for a fresh hearing notice with an adjourned date. So in this case, it is not possible to delete this entry because we want to keep a track of all the records and events that has happened. So you simply just put in a memo or a comment section, you simply put a line saying a request for adjournment has been filed, awaiting new hearing notice. So now if that if this is there in place, the person who is looking at your docketings, if all the docketing has been done on a timely basis for per day basis, they will know they will in the comments section without even actually going to the attorney or the paralegal to check whether what is the status of this case and whether they need to raise a red flag for that or not. So communication tools in the IP docketing software also play a really important role in aiding collaboration between different team members. The sixth point, I think, in my opinion, is one of the most important features of a IP docketing software is customization. Because no two firms are alike, no two companies are alike. The systems and protocols that they have in place will be different, and they need to have a software which can be adapted to the kind of usage and protocols that they have in place. And usually what happens is you may get a package of a IP docketing software, but you will need to improve on it to fit your firm's or your company's needs. So it should be customizable, and we've seen that some of the best features come from customization because the idea is that you want to simplify the entire process of IP docketing, and it should fit into your overall process of things. So this is a very important feature with respect to a docketing software. Then, of course, it should have an easy to use interface. It should allow users to quickly enter and view deadlines and important information without having too many cumbersome steps to get it done. Then it will have reporting and analytics features. Now, these are important for allowing the user to track progress, identify trends, identify areas for improvement. So if you're frequently missing or coming near a nearly missing deadlines for discovery, audit trails through reporting might help identify why. So basically, these are features which are important for literally every single team in your organization will rely on some or the other form of reporting and analytics, whether it is to check whether you have any daily due dates which need to be taken care of, whether you want to plan your week for the next, plan your week or plan the month ahead of time, or if it's for the management to see how much workload is there in the table, will they be able to meet the March due dates? Do they need to take care of any additional criteria to make sure that the system happens flawlessly? Whether there's an accounting team which is trying to pull out like a report of seeing if there is there any matter which has not been billed, other matters that are being billed need to be do we need to follow up with clients for payment? So literally every single team in the law firm will be using this reporting and analytic feature of a IP docketing software. The last one goes without saying that it has to comply with the relevant data security and privacy regulations, and it should protect the confidential information of your clients and organization. So I'll actually break over here to see if anyone have questions. I will take Tejal's question first. Can we also track updates or timelines of cases through docketing software? It has to be done through Excel. Tejal, if you could just come on, a call maybe, and let me know what exactly do you mean by this. So then I can.
Sorry, ma'am. Actually, my throat was not actually in a
Okay.
good condition.
Okay.
So I texted. So what I mean from this is, okay, as when I was working as a trademark attorney, so I used to make all the timelines. I used to mention all the timelines since the start of the start of the mark to the end of the registration process. I used to mention everything in the Excel sheet. So, is can this the track of the cases like on which date, like a timeline specifically on which date which filing has to be done or which filing is already done, and what is the next stage? So a lot of it happens, no, कि we keep a track of the date ki क्या मतलब what is the status of the mark right now? Is it in the opposition stage or it is in the accepted or it has gone for the examination? So all these things we do keep a track. So I used to keep a track of it in a Excel sheet. So can this also be done through the docketing software? I mean, not just for trademark, but for copyrights as well or for patents as well.
Right. Thanks for your question. This is exactly the purpose of our IP docketing software. Every single action item that you have mentioned will be entered in a docketing software. Like when it is being filed, if it's coming up for like if its date has been come, you put in all of those dates. So all these events, see all the events which have occurred already for that application will be entered in the docketing software. And based upon the formulas you may have entered in it, it will trigger reminders for you to maybe follow up to check, if you had to check if there's a new date issued, you could probably put reminders on a weekly reminders or reminder every 2-3 days. So all of these action items can be created based upon events that you have added into your file for that particular case. So in I heavily work on patents. So basically we make sure that this, and our firm also does this for trademarks as well, that you enter all the dates which have you have finished your filing, everything, you put those dates up, and then if there is any follow up required, you set a reminder so that it automatically reminds you. Because sometimes what happens is that even if your Excel sheet is absolutely up to date, like you will still have to go to it and you have to see that, hey, today what do I need to do, what reminder is falling on today. But a docketing system will be automated to send you a reminder in your email saying, hey, these are the matters due today, you need to take care of it. So
Okay.
it is possible to do take care of these timelines of cases through the docketing software.
Okay.
Ma'am, could you suggest any good software?
Thank you, ma'am.
Thank you, Tejal. May I know who is this?
Hasnan.
Okay, Hasnan. I will actually, in my next slide is basically talking about that. I see there are several hundreds of docketing software available in the market. I think Anaqua is one of the market leaders. You also have CPA Global, IP Folio, AppCall, Alf Legal. This is just the tip of the iceberg. It's not an exhaustive list. There are several leading docketing softwares in the market. But what I would like to say is that there is no fixed answer to what is a good docketing software as such. It will depend upon the features it depends upon the requirement of your organization, first and foremost. It will also depend upon the features these softwares are providing, the pricing, the reviews associated with it. So you need to figure out what is the best fit for your organization. And like I said, that most of the times what happens is that although you will subscribe to a specific docketing software, based upon your in-house organizational needs, you will be developing on that base to make it more suitable for your organization. So in
Meenakshi,
addition to these, there are also several other service providers which do provide. For example, Denemeyer is one. We're going to look at an example of Denemeyer software towards the end of our session. And then you also have several ERP based platforms, which, like I told you, you can get the package and then you will develop on it based upon the need of your organization. Okay, we have a question.
So, ma'am, one more point I wanted to ask.
Yeah.
How do we learn these softwares? So, are these software individual? An individual can access it, or only professional working in a law firm can access it?
See, these softwares, what you will need to do is you will have to get a subscription for it. So
Okay.
basically, you do a market study of what are the possibilities and stuff, and then you reach out to a few to understand, what is the features they provide, what is the costing they provide. Like I can tell you, like for example, Anaqua is one of the best, but it's also one of the most expensive. And maybe that's why a lot of organizations may not be able to afford it. So you will have to see in your affordability criteria which software can be used. They're not free for use. You will have to pay, like, there will be a fees associated with payment of it, which is why it's not something which an individual can use to handle it. Usually it has to be a firm or your organization as such that decides to, subscribe to it and, implement it in their processes.
So in short, we can say ki, if someone is freelancing, he cannot use it.
Not these softwares, but if you're freelancing, like what you said, one of the best ways for you to do is the Excel sheets that you are using. You may try to, automate it by using some kind of, put in some formulas to make sure that your most recent due dates will always come on top, so you don't have to screen through the entire Excel sheet throughout, like, completely. But it's possible for you to put in formulas to sort your matters based upon the due dates. So that way, when you are, like, looking at the deadlines, you can then see the most relevant and immediate deadlines right on the top. So that is something you can consider if you're trying to do it for your
Yeah.
personal use. But
Okay.
otherwise, like I said, docketing softwares can be a little expensive and it will require some amount of investment.
Right, ma'am. Okay, thank you.
Welcome.
Meenakshi, I have a basic question. You were mentioning about something called the rule-based calendaring feature, right?
Yes.
So, what the list, the inclusive list that you showed us just now, and which of course you'll be discussing perhaps a little more in detail.
Yes.
So these are some of the docketing softwares that are available in the market. But
Right.
when we talk about, let's say, an Indian filing or a US filing or an EPO or whatsoever, the country specific national phase filings, the rule based, or rather the timelines may be a little different. So how do we work around this? Would the software be able, is it automated in such a manner that it meets the requirements of a US PTO or an Indian PTO, or are the firms working around this?
Right.
How does it actually happen?
Right. So what I'm gonna do is I'll just deviate from this particular Excel sheet of mine. So what I had planned is I will also just show you an overview of an exemplary, docketing tool. So I will come
You
back
can
to this
please
tool
continue.
again, but this is going to
Yes.
address your query. So I thought, let me just share this for now.
Okay.
So what we are looking at is an example of a docketing software by Dynamaya. It is called DIAMS, Dynamaya Intellectual Asset Management System. So like you can see on the screen, it has different, like, modules for different features of IP. So for example, for pertaining to patents and searches for inventions, everything can be put into this particular module. Designs would go here, trademarks, brand profiles, logos would go here. Matter management could be predefined, and usually, like, it could be something like oppositions, court matters, etc. You can add the details of your companies and contacts through these modules. And you will have, like, financial tracking. If you need to keep a track of the invoices pending, raised, etc., you will have features for that as well. So here there is something called utilities. So this is basically not something which all the users in the firm will use, but this is where you can actually add a formula for any deadline which is, like, not already in place in your system. So most of the times when you talk to this your service IP docketing software provider, they will already have inherent inbuilt formulas for most deadlines. So it will be in place. For example, when you're looking at patents, I will show you this option. Basically, you will have an option of selecting the country. So when you select the country as India, then the deadlines will be based upon Indian law. Then if you select the country as US and Europe, the deadlines will automatically get calculated based upon that. Right?
Got it.
If in case it is not present, let's say there is some deadline, and it can happen, which is why this has to be, like, you should have access to basically make modifications to it. In case you do not have a predefined calculation for any particular deadline based upon the entry date, then you can go under the utilities option and add that formula for it to take care of it. So this is somewhere where you can add those specific formulas for a specific due date, which is not already accounted for by your docketing system, so that you can make these modifications under the utilities criteria and make it like, more adapted for your usage.
Got it. Got it. Thank you.
Ma'am,
Yes.
ma'am, so do we insert all these informations into the software, or it is already there?
So most of it, a lot of it will already be there, because these docketing software companies, they know who's their audience. I'm sorry, they know who's their client base. So a lot of it will already be present. And if something is not present, then you will have somebody assigned in your firm. Like usually these accesses are not given to all the firm members or all your organization members. There will be specific docketing specialists who, like, use this in and out, who will have, like, limited people will have access to make these modifications at their end if it's not there. And the software provider, you can always get in touch with them. If you have any queries on how do you add these dates, how do you add these limitations, you can always get in touch with them and they do help you out.
Okay, ma'am. Okay, thank you.
Welcome. So we'll move on to basically the benefits of these docketing system. Like, I'm sure it's evident based on our discussion so far that it helps increasing the efficiency. It's nothing like automation, and law firms look at automating everything as far as possible. Whatever can be automated, it is a real time saver. But I would like to tell you here that there will be um, there will be specific people who are assigned to make sure that although everything is being automated, you will still want to cross check that the due dates are, yes, the due date, like even though like I told you, the calendaring system is there, but even then you will still want to check that, hey, okay, I entered the docketing date, yes, it has captured the RE date as so and so. It is going to take you less time, but a double cross checking of verification of the update has actually happened or not is very important. Because you don't want to, sometimes your system may be slow, your network may be slow, and you may think that you entered the date, maybe you didn't take the date. So you need to have a second round of verification to make sure that the task has been suitably updated. So that is some second layer of a verification process which firms will anyway have to keep to make sure that there is no error in the docketing process. The other things, which is it reduces errors, it minimizes the risk of missing deadlines or making data entry mistakes. It enhances collaboration, like we discussed, and it helps in improving the compliance of all the legal requirements and procedural guidelines. So in all of this, the role of paralegals and docketing specialists is absolutely key. They play a very crucial role in maintaining accurate and up-to-date records. They're largely responsible for entering and updating, managing information in the docketing system. But I would like to just clarify that it all will come down upon your organization structure and the predefined roles of who needs to do what. Attorneys will also be expected to use the docketing systems, because for matters that they are handling, or they would be needed to be reminded sometimes that, hey, you have to work on this draft. It has been assigned to you 10 days back and you haven't worked on it. So they will also get reminders, and when they actually send out the draft from their end, they may also be required to go and update, saying, okay, fine, draft is sent on so and so date, send reminder to client after 2 weeks. So all of that processes will who really operates the docketing system for which feature will be dependent upon the organization's layout and structure. Then paralegals and docketing specialists will also support attorneys in managing and organizing the legal documentation, help accuracy and attention to detail to avoid error, and ensure compliance is of paramount importance. So for this, basically, training and skills are provided for docketing specialists. Usually, when the firm subscribes to something, anybody who joins new in the firm and organization will be given a training on how to use the firm, what are the different features of this docketing system, and what are they expected to do. So there will be a training which is going to be given to the specialist. Technical proficiency is important. Over time, they are going to be expected to be proficient in using this docketing software and the related tools. Now, here I would just like to clarify that there is a difference between a docketing specialist and somebody who is doing simply data entry. So now data entry simply involves you to take some information which has been given data, and feed it into another source. But here, the person who is doing it should still have, although the docketing system will have formulas involved, which will automatically update some features, but the person who is handling the matter should have some kind of legal knowledge, understand intellectual property laws and regulations, and understand what are they expecting of the docketing feature. So when they're adding the filing date, they are expected to know that these are the triggers which should automatically be generated by the firm. These are the dates which should automatically come up. So that amount of basic legal knowledge will be expected of a docketing specialist. Then they should have effective communication with legal teams and stakeholders, and they should be able to efficiently manage and prioritize tasks within the docketing system. So now, before I go on forward, we have spoken so much about deadlines, and like docketing system are helping you manage these deadlines. They're trying to ensure that you don't miss out on these deadlines. So what exactly are these deadlines that we are talking about? So I am going to give you an overview of some critical filing deadlines in patent law. I understand that you have already gone through these in your previous sessions, but that was from a perspective of understanding, the overall perspective of what of your patent law, patent filing, what happens. But here now, when we look at these deadlines, we are thinking of it from a docketing perspective. And anyone who comes across these deadlines, how are they going to use a docketing software to docket them? So we'll start off with deadlines in patent filing. Largely in patent, your deadlines can be divided into three phases. One is the initial filing phase. That is where you're conducting any patentability searches and up to the time where it's actually filed. And post filing, if you have any formal requirements to be met, all of those are taken care of. Then the second phase is an examination phase and due dates which are going to be associated with that. Finally, you will have that, yes, your application is granted. What are now the deadlines? You have to look into it. So we start off with patents. And as you may recall, that an ordinary patent, so basically a patent application, if you're filing in India, now the deadlines which I'm giving here is pertaining to mostly Indian law. You will have similar deadlines for other countries, which is going to be specific and which I may mention a little bit here and there. So over here, if you look at this, an ordinary application in India is an application which is directly filed in India. It could either be a provisional application. So let's say if a provisional application is filed, in your docketing system, you will add the date of your provisional application file. It will automatically update that the complete application is going to be due in 12 months. And it will generate reminders to send to the client saying, okay, let's say after 6 months, it sends a reminder to client saying, okay, 6 months have passed. I hope you have additional data available now. Please provide your instructions to help us draft the complete application. So this action is going to remain open till you enter the date on which you have filed your complete application. Now, if you want to file a conventional application using this as a provisional application, you also have 12 months to file a conventional application or 12 months to file a PCT application. So those can also be, now depending upon what type of system you have in place based upon your firm's policy or your company's policy, you may also trigger reminders for PCT application due date is this, conventional application due date is this, so that those fields are open to help the organization think whether they want to go ahead and file only in India or whether they want to also file a conventional application or PCT application. So once you have filed your complete specification, this application is usually published within after 18 months of the priority date. So now of late, the patent office, Indian Patent Office is extremely fast, and the turnaround time has reduced so much. But earlier there was a lot of pendency which was happening in your publication of applications. So an application does not go under examination till it has been published. So then firms would have had to put features of whether publication has happened or not after 18 months. So follow-up reminders had to be sent to the patent office at that point of time to ask them to publish their application. So that was a feature which you could add in your docketing software if there was a need for it. So this is about your ordinary application. Now, conventional route also, like I told you, within 12 months from the priority date, it would be entered. And if it's entered, you add all the relevant information pertaining to it. PCT application, once it's filed, one of the key features of your PCT application is it is allowing you to file national phase applications in countries of your choice. Let's say you want to file in US, Europe, etc. So you can file 30 or 31 months from the date, earliest priority date. So there will be a docketing feature which will, like, let's say a PCT application has been filed. The PCT module will automatically, based upon your priority date, send you reminders for 30-month filing and 31-month filing of national phase. So that will be something which will be a key feature of your PCT module. Now, moving on from the filings, when you go to the examination phase. So now let's say you have been issued a first examination report from the patent office. You will add the date. As soon as you get that, you will add the date of when was the FER report issued by the patent office, because this is going to trigger a 6-month deadline for filing the response. Your response has to be filed within 6 months. It can be extendable by an additional 3 months by filing the required request for adjournment. And then you also assign the person who is actually looking into the FER response. So the name of the team or the person who is handling it will also be updated in your docketing software, so that reminders can go out to that person saying you need to look after this deadline. Once your response to first examination report is filed, you may get a subsequent examination report, but usually what we next get is a hearing notice, where you get a one-on-one opportunity to discuss the pending objections with the examiner at the patent office. So once a hearing notice is issued, you will have to you will docket the date on which we received this hearing notice, the date for which the hearing is scheduled for. So usually patent office tries to give you 1 month, usually gives you about 30 days at least to prepare for the hearing. So you put in the date for the hearing. And when you do that, the docketing software you will usually do is, of course, put the date of hearing. It will put an earlier reminder for you to send a detailed strategy note to the client so that you can get the instructions for that. Once you have attended the hearing, you will be required to go and enter in the time saying, okay, hearing was scheduled for 1st March, attended on 1st March. This is going to trigger that response is now due within 15 days from the date you have attended the hearing. So this will automatically now get updated that hearing response needs to be filed. So when you do file that response to hearing in 15 days, it is automatically next going to take a trigger to take that now that all the matters have been done, an invoice needs to be raised. So a billing reminder will be generated, and this would be generated to probably the person who's in charge of raising such invoices in your team. So automatically, usually that person's name should come up. So this is just an example of in a way in which you can use IP docketing to streamline the workflow of a matter in your firm. But like I told you, all firms work differently, and the way some of these features can be done can be different from firm to firm based upon their practice. But like you have seen, mostly almost everything, you try to keep your IP docketing software updated with all the events, and it will basically be formulated like, it will have inherent formulas to give you the next task and to do matters to keep you on track to make sure that we are not missing out on something essential. Now, once you file your hearing submissions, the case may actually may proceed towards grant, or it may be rejected. Now, let's say we have received a notice of rejection, we report that to the client saying, okay, this case has been rejected. You have 1 month's time to request the controller to review the decision. So that will be a 1 month. So if the client comes back and says that, yeah, we filed some additional data that was overlooked by the patent office, so we want to file a review for controller's decision. So once you get that instruction, you will update your docketing software that it's going to be the timeline will be 1 month from the date of communication of the refusal order. So the basic timelines of the IP matters in India is again captured in this table. The provisional to complete specification PCT convention application request for examination. I marked these in red because these are very, very critical deadlines. And if you miss them, you basically miss out on your patent because there is no way you can revive or file a petition or request the controller that there was a mistake, there was a lapse at our end, please try to revise these deadlines because it's simply not possible. So these are some very key deadlines for which you do not have any extension possibility. So it has to be, you have to handle them with utmost care and so that you don't miss out on such important due dates. Then I've also just mentioned the withdrawal of application. If your client is wanting you to withdraw an application already filed, you must do it within 15 months because by 18th month, it is already going to be in the process of it being published. So any withdrawal request has to be filed within 15 months from the priority date. And the next are some formal requirements, which like usually you can also have like your docketing system to take care of these deadlines as well. And most of them are also automated of late. Now, for example, you have filed a patent application in India. The next four matters that I've indicated here in the table are some formal requirements which need to be taken care of. So now a proof of right is basically a document which goes in the form of a Form 1, or it can be an assignment document where the inventors have assigned their rights to the applicant. So this has to be done 6 months from filing. So usually what docketing softwares could be like coded to do is that once you say that I have filed my application on January 1st, 2024, it will automatically calculate the due date for proof of right as 6 months from filing. It will calculate the due date for submitting power of attorney as 3 months from filing. So power of attorney is where the applicant is giving their consent to the law firm saying yes, we allow the law firm to take care of actions on behalf of these applications for us. Next is Form 3. Form 3 is basically a form which is keeping the patent office updated of your filings in foreign applications. So yes, you have filed in India, but if you have also filed in a different country like US, Europe, etc., then you need to keep the patent office informed of such filing within such. First, Form 3 has to be filed within 6 months from the date of your filing of the application, and thereafter it's a continuous process. Every time there's an update in terms of you filing a new application, you need to keep the patent office informed within 6 months of such an update. Form 5 will be usually signed in case there's an addition of inventor. If not, it's just the patent agent who has to sign this. But these are documents that need to be submitted as soon as a patent application has been filed in India. So your docketing system will have mechanisms of entering these timelines, and you could then add the reminders how often you want it to remind you. And once it's done, you will put in the date where you have actually taken care of these formalities so that you can close this loop. We have already discussed the reply to FPR and hearing submission in the previous slide. Okay, so Dr. Pratima has asked us to briefly explain what is proof of right. So now I'll go back to that. So proof of right is basically a formal requirement. So when you file a patent application in India, you will have a disclosure, which is the key part, which will have claims, disclosure, which is defining your invention. And then you have claims, which is defining the scope and boundaries of your application and invention. So in addition to that, there will be a few additional documents. There's a document called Form 1, which is a request for filing a patent application. So in this, basically, there will be a requirement where the inventors have to assign their rights to the applicant. So there will be a place where the inventors have to sign saying, okay, I am a true inventor for this invention. I have made this invention and I'm assigning my rights of this invention to the applicant. So for example, I'm just giving you an example. Let's say you have a university which has certain researchers and students working over there. So while they have done the research and they are the true inventors for it, they may be assigning the rights of this patent to the university itself. based upon maybe some agreement which is there in place between the faculty and students and the university. So this is one thing. It is not necessary it has to go in the form of form 1. It can also go through a assignment, like it's basically like an agreement. It could be a worldwide assignment which is going to be applicable in India as well. So for example, this could be like in US, usually what they do is they file an assignment directly, where it's like an agreement, it's like a legal agreement you guys would have discussed, where they define that the parties, who are the parties going to be, that they are the inventors, describe their role in the invention, and say that they are assigning the rights to the applicant. So that is also going to work. So this is proof of right. Either you file a form 1, which is signed by the inventors, or you file any assignment, which is like, where the inventors have signed and given their rights to the applicant. So I hope this is clear. Only one thing I would like to add here is that this requirement is not there if the inventors themselves are the applicants. So for example, let's say if the students have filed, created some invention and they are the applicants, in that case, you will not have, like, if individuals itself who are inventors are also the applicants, in that case, there's no requirement of proof of right, because then you don't have to assign your rights to the applicant because you yourself are the applicant.
Correct. And likewise with the employer-employee, right? So there
Exactly.
are employees in the organization and they assign their rights to the employer. So
Correct.
the employer, so there's the inventor and then there's the applicant.
Yes.
Is that right?
Correct.
Thank you.
Okay. So this we were looking at Indian patent deadlines. So we're coming towards the end, the grant stage. So once it has been granted, a renewal fees will be applicable within 3 months from the date of grant of patent. So as soon as your patent application has been granted, within 3 months you need to pay any residual renewal fee. So for the first and second year of your patent, there will be no renewal fee applicable. Annual basis fee has to be paid from the third year onwards. So let's say if your patent has got granted in the 5th year, then you, within 3 months from the date of grant, you have to pay the annuity fees for the year 3, 4, and 5. And thereafter, you can pay on an annual basis. Extensions of 6 months are available if needed for filing the renewal fee. But if you do not file, even after this extended period, if you do not file your renewal fee or annuity, your patent will cease to exist, and a restoration of it can be done only within 18 months. The next requirement after you file a patent is, in India, as the Indian laws, is filing a working of patent statement. This is basically done through Form 27. It has to be done by September 30th of each year for the previous financial year. You basically need to just inform the patent office that, hey, I've got a patent on this technology. Are you working this technology in India or not, is all that you have to say. If you are working it in India, that is, if your invention is being used in India, the amount, the quantum, and the value of working in India, or whether if it's been imported into India, has to be mentioned. If it is being like licensed and sub-licensed, you can mention that as way of working, saying that, yes, I'm working it by licensing it to XYZ party. So with this, we conclude broadly the features of getting an Indian patent application from, from filing till its grant, and what are the deadlines which we would look into entering into our IP docketing system. We will now look into a PCT application, which is basically like an international patent application, which gives you the opportunity of filing a national phase within 30 to 31 months once you have filed it. So what is key to note here is, if your client says that they're interested in filing a PCT application, you will check if there's any priority date, because that will trigger the deadline within which you have to file it. So you file the priority date, enter the priority date into your docketing system, and your PCT application must be filed within 12 months of your priority date. The PCT application, the PCT authorities will issue a examination report around the 16th month or maybe sooner. This is called International Search Report and Written Opinion of International Search Report Authority. So a response to that can be done under two provisions. One is under Article 19 and one is under Article 34. So if you're filing under Article 19, it only allows you an opportunity to make amendments to claims, and this has to be done within 2 months from receiving this examination report or by the 16th month. So whichever is later. The other way of responding to this is giving a detailed objection. If the objections are super comprehensive and you want to rebut the objections by actually giving arguments, making claim amendments, you can file a response under Article 34. File it with demand. The deadline for filing this is going to be 3 months from when you receive this examination report, or 22 months from the uh, priority date. So these, like, the law firm can decide what they want, what is a due date they want to keep in track in the docketing system, whether they would like to take 18 months, 16 months and 22 months, and if needed, if it has 16 months has already expired or 22 months has already expired, then they can go and change the automated date accordingly. Finally, the client, this is the, like I told you, the 30-month and 31-month date is going to be set, and it's going to be prefixed. That will be there from the time you put the priority date and the filing date of your PCT application. This is something which will automatically be there because it's a very, very critical deadline. And a lot of countries like India, if you miss this deadline of filing within 30 month or 31 month, whichever is pre-decided for that country, if you miss this deadline, it's not possible to file a PCT application in those countries uh, after the lapse of the deadline. So this is a very important deadline which you have to be extremely careful of. So you will have several systems in place to ensure that that does not happen. So we have finished our patents. With this, we finish our important deadlines for Indian and PCT patent matters. We'll just look at a few deadlines associated with trademark and design as well. I'm not very sure, Dr. Pratima, have you already finished your session on trademark and designs?
Yes, we have, but I think this chart would also be very helpful for the students now. You
Okay,
could just
great.
briefly. Yes, we have done a couple of sessions on registration of trademarks and designs in the last sessions.
All right.
But this is quite helpful.
Okay, so this will be like a refresher. Just a reminder, we are again looking at it from docketing purpose and not from the technical purpose of what really goes into a trademark or design. So now for a trademark application, once you get it, once a trademark has been filed, you enter in your system that, okay, this has been filed, trademark has been filed, you add the date of filing. Usually all formal requirements are taken care at the time of filing itself. So then you don't, unlike patents, you don't get those triggered reminders for proof of right, Form 26, etc. You may get a notification from the trademark office called formalities check fail if in case any formalities have not been timely taken care of, have not been taken care of. So you get 30 days time to respond to this. So once you enter the date of the date on which you receive this formalities check fail notification, you will have 13 days from that to take care of this deadline. Then you will have an examination report which may be issued if there are any objections pertaining to your trademark application, for which again you have 30 days to file this your response. An extension of 1 month is possible if needed. And usually if all the objections are taken care of, your mark is published. A publication of mark happens usually within 4 months. Then you have notice of opposition, which may be issued. So basically, if there's an opponent who opposes your trademark, this may happen. This has to be filed within the 4 months of publication period. So after this 4 months publication period, it's not possible to file a request for opposition. A counter statement by the applicant will then be filed within 2 months from the notice of opposition. Any evidences which have to then be filed by either parties, they could be filed within 1 month from the respective opposition respective statements or evidence filed. Now the term for a trademark is like 10 years, and your mark is valid for the next 10 years, and renewal can be filed before 1 year of the expiry of the renewal deadline. So you can continue to renew your trademark every 10 years, and the last year is going to be critical year, and this is where your docketing system will come into place, because you will not remember a deadline which is 10 years later. So you have to ensure that the deadline is intact, correctly mentioned in your docketing system, so that it can remind you a year before, in your 9th year, that hey, your trademark is up for renewal on so and so date. So that was trademark matters. Let's quickly look at design deadlines as well. Once you get the design, so basically there are two ways to see it. Now let's say usually in design applications, sorry, this is for trademark. In trademark applications, you may also have to conduct a search. So you can also adapt your IP docketing software to enter that a search has been conducted and the application is yet to be filed. You may just be waiting some formal instructions from your client to go ahead with the filing. So your docketing system can also be tweaked to account for such additional matters that you are taking care of, which is why I told that law firms will, and all organizations will basically have to tweak whatever platform they're working on to make the options suitable for all possible scenarios which may come up in their matters. Now moving on to design, once you have filed a design application, you add the date on which it has been filed. Post that, once the FER examination report is issued by the design office, a response has to be filed within 6 months of this FER, and it can be extendable by a period of 3 months. Usually may proceed towards just grant if there is no major objection. If there is any objection, pending objection, a hearing may be issued with the design officer and controller, and there is no set timeline to file the response. Usually what happens is, depending on the complexity of your matter, you can discuss with the controller on how much time you need to make your submission. Usually, since it may not be too very major, it's usually 5 to 10 days. But if you need more time, you can discuss that with the controller and pre-decide that time. So your docketing software will have to accordingly be updated based upon your discussion with the controller. Then you go and file. This was in case of a direct filing. Let's say you want to actually file a conventional application. Let's say a design application has already been filed in US, and you are trying to now file it in India. So you have to file it within 6 months of the first design which has been filed, if you want to take priority of your first application filed in US. In the remaining deadlines remain the same. Only additional requirement will be that you have to submit a certified copy of priority document for claiming this priority, which has to be within 3 months from the date of filing your conventional application. Now, a renewal of copyright once your design is registered, you have a 10 years registration term. It is possible for you to renew it by a period of 5 years by paying the renewal fees. So you will have a suitable docketing feature which is going to record these dates, so that it reminds you in time. If your client wants to take a renewal of 5 years, you can send timely reminders and get their instructions and then file this on time. If a request for cancelling has been filed, so if a cancellation petition to cancel your design application has been filed, a counter response for the same can be filed within 1 month from such receipt of such petition. So these are the broad deadlines involved, overview of the deadlines involved in patent, trademark, and design matters. What is basically the consequence? Like, one of the key features of IP docketing software is that you do not miss on filing these deadlines. Because once that happens, you never know which invention could actually be a multi-million bagger for your company, which could be strategically important for your evolving your business. So you can never really take a chance of unintentionally allowing something to lapse. Sometimes it may also be that you have licensed that technology to a third party, and if you have not been in a position to maintain it, let's say you fail to file its renewal deadline, even within that 18 months restoration period, there's nothing that you can do to revive your patent. And if a technology has already been licensed, you're going to incur even additional losses and maybe bad faith in the market. So you would not want to get into such a situation and allow an IP to lapse unintentionally without taking a business call on it. So this is absolutely critical to make sure that you like IP docketing system has to be super robust and in place so that you avoid such loss of rights and protections. Also, there are some deadlines, for example, which is which is possible for you to if you have missed out on them, you can probably pay a penalty and still meet that deadline. But this is again going to come at an additional cost to the company, which you would want to avoid. Now, an example of this could be Form 1, which I told you, petition, a proof of right petition. So let's say that you have, if the applicant has failed to file it within 6 months of the filing, so then there will be, during the examination stage, it is something the examiner is going to pick up saying, okay, fine, these are the formalities you have not met. And if he may give you he will give you an opportunity to file it within, along with the response. So at that time, there will be a petition you had to file for condoning the delay involved, which will require you to make a additional late, petition fees, which is a late payment fees. So this could incur additional cost to applicants, and they would want to avoid doing that. Thirdly, it may lead into potential legal disputes, could and challenges from competitors in situations which you would want to avoid. So, in best and for the overall health of your IP, it is best that you try to avoid such situations and have systems in place where you can actually meet all legal compliances in a timely manner. So before I come to the last slide on my slide deck, I'm going to go back to the overview which I wanted to share. Just wanted to check how are we doing on time. I think we have only 6 minutes left, right?
Yeah, that's okay. We can take about pretty much, yeah, it's 10:53 now, so we can close it. That's not a problem.
Okay, I'll try to go through this a little more quickly, but I wanted to share an example of a docketing software with you because everything that I've said is very theoretical. And I thought, while it's not possible for me to show a live demo because of sensitive client information, I wanted to give you an overview of how, exemplary docketing software can look like. And some of these features are going to be basic in everything, and based upon, there will be additional features in everything, but at least the basic features is something I wanted to show you through the slide deck. So like I had shown you earlier, these are the different modules involved in it. So for different patents, trademarks, you have different modules. You will have options where you can add, let's say I'm working with a company for the first time, I have a new client, I can add their information over here. It will generate a code against their name. So in future, and I can also define whether this is a client for me under patent, is it a client for me under trademark. I can make such kind of definitions in the company module so that I have all the information and the details of the contact person docketed with me for all my future references. Next, we can look at the patent module. So like I said, so basically if you click on that patent button on top, it will take you to another page, which like you can see, you have clear fields defined on where you need to put in the information. So a docket ID will be created for each new case in a firm or in an organization. So the idea is that you're going to be able to define your case using this docket ID through all your softwares. So all your emails, communications also will be parallelly uploaded for that docket ID in a separate platform, or maybe it could be in the same platform, depending upon what type of subscription you have. So you enter the docket ID for that matter, add details such as the title, details of the applicant, inventors. Now, under attorneys, you could define in your organization who are the attorneys who are going to be responsible for this matter, so that all relevant communications from this software can be directed to those specific attorneys. Then details, then you can add details pertaining to the abstract, the long title, the memo section would be, for example, any additional comments which which you need to explain the situation, or if there's any standing instruction from a client saying please use only so and so email IDs, do not use these email IDs, or if you have any kind of instructions from client which you want to like docket, they can be put in this section. Now I would just like to just simply mention here that this long title and abstract are also very helpful, because sometimes firms and organization may want to do a conflict check based upon a technology. Now, let's say if you're taking up a new client, there may be a requirement for you to do a conflict check. And they could either give you names of competitors who, if they are your existing client, you may then have to see whether you can work with your new client or not. Sometimes they could say that this is my technology. If you're working in this technology, I do not want to work with you. So in that case, it helps if you have uploaded your abstract and long title, because then you can search in your database for technology where you've already worked in this field, and it helps your process of doing a conflict check and makes it much smoother. You could add details of prior arts if under this particular section if needed. Then this is where you could add any additional details in terms of the client who has given you the case, who is the applicant of the case, the attorneys, etc. This is the most important section of your patent module. Here is basically every single thing I showed you in this flow chart of what are the important deadlines. This is where you will come and populate it. So for example, you will say your application number is this, application date is something you're going to enter here. You're going to add here what type of application it is. Is it a PCT application? Is it a ordinary application? Is it a like provisional to complete application? So all those details can be entered here. That if it is seeking priority from a different country, you add the priority details in this section. What is your current status of the application? Is it like, yet to be filed? Has it been filed? Is it pending with patent office? Those details can be put up in the status section. Once it has been published, you add the details of publication over here. Request for examination date is to be entered here. So annuity dates, file status, all of it. So basically everything is like all the events of an act of a patent application can be entered in the relevant fields over there. Additional features which are not possible over there can then be entered here and linked with the module to suitably remind you as well. So if you want to link any documents, you will have options for that. And this is a diary module. Now, this is like one of the most important features of for a user, like from daily use perspective. This is where is the most important section of the patent module, because if I'm to open my IP docketing software and I say to do, I will just get a list of matters which are pending in this, and I will know if I am the person responsible. My name would come up somewhere here. The due date will be here, and reminder date is going to be here. So I can just take care that I have taken care of that matter. Let's say I had a hearing to attend today. I have attended the hearing. I will just simply have to put the date over here saying I have done it. So then the next actions will automatically get triggered, and the responsible party will be pre-decided. So their names would also get entered. If I am supposed to be the responsible party for those and not the pre-decided parties, then all I have to do is go and edit it and put my name over here so that the reminders come to me and not to someone else. So this is like an overview of the patent module. So I'm not sure if we have time to look at all the other modules. So I'll just break up for questions here. Do you have any questions on how this works, which I can help clarify?
Yeah, any questions? I think that's pretty much clear through the discussions and the presentation that was shared here. Thank you, Meenakshi. I think this was a very, very important part of the learning, because, we have always wondered how law firms and large organizations really manage that large deck of IP that comes to them, or, in terms of meeting the timelines, which you mentioned that there are some really serious consequences of missing out the timelines. So I'm sure the participants here who are attorneys and both law students, potential IP professionals, have much takeaway here in terms of exploring these tools of what best they can utilize, for their firms, for their organizations, in terms of maintaining a proper IP docketing system. So I think this was a really, really useful session, and thank you so much, Meenakshi. And should any of the participants have any further questions to Meenakshi, you can please feel free to write to Meenakshi, or you can just forward the mails through us. Maybe Dr. Anchal will help you reach out to Meenakshi. So any which ways, we will get back to you for any further clarifications or whatsoever.
I would be
Thank
happy
you.
to address that.
Thank you for a wonderful session, Meenakshi.
Thank
And
you
it
so
was
much, Dr.
great opening
Pratima.
session.
And great, thank you so much. And I would like to thank all the students as well. It was very interactive session and I quite enjoyed addressing your queries. So if you do have any further queries on this subject matter, you can reach out to me anytime, no problem at all. So I would just like,
Thank
before I end, I would just like to mention that I have given an assignment on this topic. I would like to believe that is a fun assignment for you to do, because everything which you need to address, so it's going to be a MCQ questions, and everything that you need to answer those questions would be there on those in the slide deck which I have shared today. But I think if you just listen to the session, you will be able to get all the questions right. I have no doubt about that.
Great. Thank you so much. We'll forward the assignment as well.
All right. Thank you so much.
Thank you, Meenakshi. Thank you. Have a good day.
Thank you, ma'am.
Thank you.
Thank you.
Thank you, ma'am.
Thank you all.
Thank you. Bye.
Bye.